So thank you, Michelle, for the kind introduction. So I'm going to be speaking about, as Michelle mentioned, some very recent reforms to Quebec's surrogacy laws. So Bill 12 passed really just recently. Okay. Okay. Reformed really quite recently. So May 31st, Bill 12 passed. There's parts that are technically now in force. There's parts that will be enforced in the next year once regulations are adopted. And really what this does is kind of three main things. And I'm going to get into a lot more detail on this, but it institutes this kind of very significant regulation around surrogacy arrangements. It seeks to clarify the parentage of children who are born through surrogacy. And it also creates important restrictions or significant restrictions on cross-border surrogacy. And so today I'm going to present a little bit on how Quebec has responded to surrogacy prior to Bill 12. So what has been the law up to this point, to provide some context for Bill 12's reforms. I'm going to speak about what Bill 12 does. It's really quite technical. There's a lot of detail here. I'm going to kind of try to keep it at a high level. But if you find it a little bit complicated, that's in part because it is. I'd be happy to answer further questions during the Q&A. And really what I want to spend most of my time on is commenting on these proposed reforms. And I've been thinking a lot about whether they're going to achieve lawmakers' stated objectives. And so in introducing these reforms, lawmakers said they wanted to do kind of three main things. They wanted to seek to better protect surrogates from concerns they have around potential exploitation. They wanted to protect the children who are born through these arrangements. Again, this is the language that's being used by lawmakers, and they wanted to better account for the needs and lived realities of Quebec families. And so they want to better support and recognize intended parents who are building their families through surrogacy. And kind of my overall assessment of this bill is that while it will go some way towards supporting these objectives, it has really important limitations and problems. I think it may actually run counter to lawmakers' objectives in important ways. It may leave some children in a vulnerable position. I think it interferes in significant ways with surrogates' autonomy and decision-making about who they carry a child for. And I think it also complicates family building for some intended parents as well. And so overall, my assessment is I don't think that this bill adequately accounts for surrogates and intended parents' experiences or balances their interests in the way that I might have liked to see this bill do so. And I think it also leaves a lot of questions currently unanswered about what regulations will look like in relation to this bill. And as a result, I actually still have a lot of questions about the effectiveness of some of the provisions in terms of supporting objectives until I see what those regulations will actually look like. Okay, so what has surrogacy looked like in Quebec up to this point? Well, as I've kind of already alluded to, surrogacy in Quebec has been largely unregulated up till this point. And so as a result, what I'll refer to as default family law rules, so default rules that would apply where someone is not born through surrogacy, have applied in cases where a child is born in Quebec to a surrogate. And so the surrogate, as the person who gives birth to the child, is presumed to be the child's legal parents. This is the case across Canada. This is not unique to Quebec. But basically what was happening in Quebec was the surrogate would be presumed to be the child's legal parent. One of the intended parents could be recognized typically as the child's second parent, and then their spouse would apply to adopt the child so that the surrogate could transfer her parental rights to the second intended parent. And they're doing this through a process called the special consent adoption. This is a provision that really is typically applied in relation to step-parent adoptions, but it's been used in this context basically to allow for this transfer of parentage. The other thing we've had in Quebec is we've had this one provision that's existed since 1991 that has stated that surrogacy agreements are absolutely null, okay, within the province. And this provision was initially interpreted as meaning that potentially that surrogacy could be illegal within the province. This was clarified now almost 10 years ago by the Quebec Court of Appeal as not meaning that surrogacy is illegal, but rather that as communicating that any contracts that are drafted between surrogates and intended parents are unenforceable. And so that, let's say if a surrogate refuses to provide consent to give up her parental rights, so doesn't agree to the special consent adoption, she can't be compelled on the basis of the contract. You can't enforce the contract to transfer parental rights. The other thing that's, I think, important to note, because it does have some application in relation to Bill 12's provisions, is that across Canada, it's illegal to pay a surrogate. We have a federal law that prohibits payment to a surrogate, but a surrogate may be reimbursed for her out-of-pocket expenses. And so effectively, lawmakers have sought to ensure that surrogates basically are not benefiting from acting as a surrogate, but that they also aren't out of pocket, aren't incurring losses in order to act as a surrogate. And surrogates also need to be over the age of 21 pursuant to this federal law as well. Okay, so that's kind of Quebec law in a nutshell, what it's been up to this point. So what does Bill 12 do? Well, it repeals Article 541, so this provision that says that surrogacy contracts are absolutely null, and it introduces a series of provisions pertaining to surrogacy. And so it introduces these general provisions that regulate all surrogacy arrangements, and then a series of provisions that apply where a surrogate lives within Quebec, and different provisions that apply where a surrogate is outside of the province. Okay, and so one of the big things that Bill 12 does is it's going to allow some intended parents to register as the parents of a child born through surrogacy without going to court. So without obtaining an adoption, without obtaining a judicial declaration, but there needs to be certain conditions that are met, and they're really quite stringent, and there's many of them. So one of them is that in order for the intended parents to register, they need to have obtained independent counseling. So both the surrogate and intended parents need to meet with a counselor to be informed, as the government has stated in the bill, to be informed of the psychosocial implications of surrogacy and the ethical issues that can arise. Okay, so they both need to meet with this counselor. They need to obtain documentation saying that they have, and then they need to go to a notary and they need to sign a notarized surrogacy agreement. So we call it a notarial acte en minute. It's not quite clear what this agreement is going to look like. It seems like there's going to be a standard agreement, but that's something that's going to be spelled out in regulations. So again, we don't really know yet what that will actually look like and what kind of provisions will be in there. But the parties need to do this prior to conception. So let's say prior to the surrogate undergoing IVF or an embryo implantation. The surrogate also needs to consent, of course, to transferring her parental rights still. In order for the intended parents to register, she needs to wait 7 days following the birth in order to provide this consent, also needs to provide it within 30 days. They provide this kind of window of time. The surrogate also needs to be over the age of 21 and not paid. And so basically they're kind of reaffirming here the federal law. Although there is some indication, it seems that the Quebec government is going to draft their own regulations about what is a reimbursable expense. And so that might not actually accord with the federal law. Again, it remains to be seen. And in order to benefit from this process as well, the surrogate and intended parents both need to reside in Quebec. And this is really important because a lot of surrogacy currently is happening cross-border. And so in order for intended parents to register without going to court, we need to have both of the parties in Quebec, and they need to have been residing in Quebec for at least 1 year prior to entering into this notarial acte en minute, this agreement. Okay, so we have all these requirements. What happens if these requirements are not met? Okay, so if we don't have a notarized agreement or the parties don't obtain independent counseling, let's say if they weren't informed about this, they don't know that these are requirements, then the legislation carves out this kind of exception that will allow them to go to court to obtain a judicial declaration. And so the surrogate would actually be recognized as a child's parent at the time of the birth, but the intended parents can apply to court to modify the child's parentage, or what's referred to in Quebec as the child's filiation. so that the intended parents can be recognized instead of the surrogates. Okay, so that's what can happen if these kind of more formal requirements are not met. There is this route for them, for the intended parents to nonetheless be recognized and for the surrogate to relinquish her parental rights. Okay, what happens if the surrogate doesn't consent? This depends on the reason why she hasn't consented. And so if she refuses to consent, the surrogate will remain the child's parent. And the lawmakers have been very clear on this. So basically the surrogate would remain the child's parent. One of the intended parents, so it seems a male intended parent, could still be recognized, but his spouse could not be recognized. And if the surrogate dies or disappears or becomes incapacitated, so she's unable to give consent, there's this presumption of consent. Although there is something in the legislation that says if she disappears with the child, then also she is presumed to have not consented. But there are instances in which there is this presumption of consent where the intended parents can actually still go to court to be recognized. Okay, what happens if the surrogate was under 21 or was paid, or if the intended parents have not resided in Quebec for a year? In these instances, the intended parents cannot obtain a judicial declaration. So they cannot go to court. They can't be kind of registered as the child's parents. They can't go to court in order to obtain a judicial declaration in the way that they could, let's say, if they hadn't met the requirements for a notarial act or for counseling. And the surrogate would be recognized as the child's parent. Even if in this instance, she had consented to give up parental rights, so would not necessarily want to be recognized as the child's parent. One of the things that's currently unclear is whether judges, when faced, let's say, with an application to change the child's filiation or parentage here, would allow still for a special consent adoption. I think that there may be instances, I think a court might be pushed to do this, I think for good reason, because it would be in the best interest of the child to have their parents recognized. But I think lawmakers haven't intended for there to be that kind of backdoor route. And so it will be really, I think, interesting to see what courts do with this when they are, I think, almost inevitably faced with this kind of situation arising. And if the surrogate lives outside of Quebec, as I mentioned, there's different rules that would apply in that situation. So let's say where the intended parents are residents of Quebec, but the surrogate lives outside of the province. The intended parents would now need to apply to the Minister of Health and Social Services for authorization to engage in the parental project involving surrogacy. So actually they need permission in advance to work with a surrogate outside of the province. And they need to decide whether basically they'll authorize that depending on, it seems, the location of the surrogate and the conditions in that particular jurisdiction or province. Again, we have a lack of clarity currently as to in what circumstances they're going to authorize or not authorize. They also need to obtain a certificate of compliance following the birth from the minister, and then they need to apply for judicial declaration of parentage. So they need to go to court. So again, it's a more, what basically the gist of this is going to be a more complicated process. Okay, so what do I think about this bill? Will these reforms better support and protect surrogates, children, and intended parents and fulfill lawmakers' stated objectives? I'm going to go through some of the main parts of the bill and just provide my commentary on that. So in relation to the rules around legal establishment of filiation, so this is this non-judicial process where the intended parents can register, kind of similar to what has been happening for some time in Ontario, if they meet all these requirements. I think that this is generally a good thing, right? This is going to save some intended parents time. The special consent adoption process is a lengthy process. It usually requires between 4 and 7 months for the intended parents to be recognized. This would allow intended parents to be recognized much more quickly. This would also reduce some of the costs associated with these arrangements because they wouldn't have to go to court. They wouldn't need a lawyer to go to court for that process. Also, if they do move towards a standardized surrogacy contract, this would also reduce costs for the intended parents as well. I think this is what they're doing. There's also, I think, really important symbolism of moving away from a special consent adoption towards the ability to register as a child's parents. One of the things I've seen through some of the empirical work that I've done is that intended parents really feel that's quite significant that they don't get to, let's say, register as a child's parent from the get-go. So they can sometimes feel quite hurt by that, and that it communicates that, they're not immediately the child's parent. And so I think that there's kind of real important symbolism as well of recognizing intended parents really from the get-go, and not making them go through this adoption process. The other thing this is going to do is that this is going to be more inclusive in terms of who can actually be recognized as the child's parents. One of the problems with what we've had up to this point with the special consent adoption process is that actually some people are unable to be recognized through this process. And this is really quite technical. I can answer more questions on this during the Q&A. But basically, I think it suffices to say that lesbian couples, single mothers by choice, and also unmarried cohabiting couples who have not cohabited for 3 years, none of them could be recognized through this special consent adoption process because of the ways in which the code had been drafted and structured around kind of the default rules of filiation. And the other thing that this is going to do as well is that this will, in some ways, further legitimize surrogacy within the province, result in greater certainty with respect to parentage, at least for some intended parents. Okay, so these are kind of some of the good things that I think come out of this. But I think there's a lot of not as good things that come out of this as well. And there's also a lot of questions that I still have. So one of the things that I think in relation to this bill is in relation to the counseling and notarized agreements, there's the possibility that this could promote informed decision-making, could ensure that surrogates and intended parents are informed of their legal rights and obligations prior to entering into these arrangements. But I need a lot more information about what these counseling sessions are going to look like, what the minister is going to be requiring through them, what these notarized agreements are going to look like. Like, one of the potential benefits of moving towards these standardized agreements is that one of the concerns I've had about surrogacy agreements that are drafted really across Canada is that they contain a lot of provisions that wouldn't actually have legal weight, and that I think some intended parents and surrogates think would have legal weight. And so I think if we move towards an agreement that potentially only contains provisions that would have legal weight, but where, let's say, a counselor can have conversations with intended parents and surrogates about their expectations around lots of other things, like their expectations around termination in the event something goes wrong in the pregnancy or something like that. I don't think that necessarily should be a legal contract, but certainly that's something people should be having conversations about. But again, we don't know what these agreements will look like, what the counseling or information sessions will look like. We have to wait for regulations to see that. And one concern I have about Bill 12 is that it's requiring parties to go to a single notary in order to enter into these agreements. Up to this point, the parties have been receiving independent legal advice when entering into surrogacy agreements. I think that there's real benefit potentially to that, especially if they need to negotiate things like surrogates reimbursements for surrogates to have their own legal counsel. And so again, I need to have more information here, I think, to properly assess what the impact of this is going to be and whether it will be beneficial. In terms of the surrogate's consent, the intended parents cannot be recognized as parents. I think that this is very problematic. I understand that lawmakers want to recognize surrogates' contribution to the pregnancy, but in doing this, we're also not providing any recognition for intended parents' connection and contribution to the surrogacy. Often intended parents have a genetic connection to the child that's born through surrogacy. They obviously have a very strong emotional connection to the child. They put a lot, they've often gone into debt and extended significant financial resources in order to undergo in vitro fertilization, in order to sometimes work with counselors and work with lawyers. And so really there's kind of a lack of recognition, I think, of that. It's also very rare in Canada for a surrogate to change their mind and want to parent the child. Much more commonly, the surrogate does not want to parent the child. And more commonly, where there have been instances, and I've seen this through some empirical research that I've done, there's been instances where surrogates have refused to provide consent initially. It's not been because they want to parent the child, but it's been because of a dispute that's arisen over expenses, let's say, that are owed to them, or a dispute over the amount of communication and contact they've had with the intended parents. And so there's all sorts of problems that I think can arise from this ability for a surrogate to not consent. And I think that lawmakers here should have allowed for some judicial discretion, as they have in many other provinces, where there is a dispute, for the court to potentially intervene and to decide who will be the child's parents. Also, the fact that if the surrogate's paid, the intended parents cannot be legally recognized, I think is deeply problematic as well. I think some intended parents may break the law inadvertently. I think some may do so intentionally as well. But irrespective of that, I don't think that the answer to that is to not recognize the intended parents as the child's parents and to potentially compel the surrogate to maintain parentage against her wishes. Would this be in the best interest of the child? I don't think so. I think a surrogate might be able to give up the child for adoption. And again, there's some question here about whether the rules around special consent adoption would apply. And I think a court might, in this kind of situation, allow for it to apply. But again, that's not something that lawmakers seem to have envisioned here. And finally, in relation to cross-border restrictions, so intended parents need to be Quebec residents. I think this was done very intentionally in order to essentially deter international intended parents, so intended parents who are outside of Canada from coming to Quebec. This has been something that has been, I think, hotly debated for some time about whether intended parents from abroad should be able to work with Canadian surrogates and whether there should be restrictions on this. But lawmakers also, in creating this restriction, are also creating the same rules for Canadians who live in other provinces who might want to work with a Quebec surrogate. There's certainly going to be surrogates in Quebec who may wish to carry for intended parents outside of the province. It's not difficult to imagine, let's say, a situation where someone's sister is living in Quebec and they want to carry for their relative who lives outside of the province. And this, of course, raises questions about what will happen inevitably where children are born in Quebec and the intended parents are not residents. Again, is an adoption going to be allowed? We don't know. And I think one of the consequences of this is that Quebec surrogates will continue to be asked to cross the border to give birth. This is something that has already been happening for some time, where surrogates, let's say in Montreal, are asked to drive to Hawkesbury to give birth, or surrogates that who live in Gatineau are asked to drive to Ottawa to give birth in order to benefit from basically Ontario's regime and to avoid these kinds of restrictions. And I don't think that it's in surrogates' best interest to be asked to drive to another location in order to give birth. And in relation to kind of the flip of this, so where the surrogate lives outside of Quebec, we have this more difficult process for intended parents. And I think we don't know currently in what situations the minister is going to refuse to authorize this, which provinces or countries would be off limits. It seemed in some of the discussion around this, there was some communication, let's say somewhere like California would be off limits because they allow for paid surrogacy. But again, what's going to happen when people don't follow these rules? Are you going to penalize the families and the children that are born from these arrangements? And, I think this raises the question also about whether other provinces should be treated the same as other jurisdictions. This is intended to address concerns around surrogates potentially being exploited in some other jurisdictions. I know that was lawmakers' concerns in instituting this kind of provision. But I think they're really kind of painting with a broad brush and treating everything kind of the same without full consideration about its implications. And so, my conclusion in relation to this, there's not a whole lot that we can change at this point. This is come into force. But I do think courts should allow for special consent adoptions where this is clearly recognized to be in the best interest of the child. And I think in relation to the regulations that are going to be introduced in relation to these notarized agreements and information sessions, I hope that lawmakers pay some attention to the empirical work that is out there about what these agreements should potentially look like and what people have found beneficial about counseling sessions or potentially not beneficial. So thank you very much. I'm going to turn over to my colleague, Vanessa Gruben.
Thank you. Yeah, that's great. Thanks, Charles. There we go. Super. Thank you. So thanks very much for having me here. I'm really delighted to be speaking today about the right to know one's genetic origin. So Stefanie has given us a really excellent overview of how this new law is going to work. And I'd like to sort of take a deep dive and look at some of the provisions on the right to know one's genetic origins. So let's just, there we go. So in order to do that, I think it's helpful to first provide a bit of an overview of the right to know one's genetic origins in Canada, to provide some context and history to how this conversation has been happening over several decades, really, in Canada. And this is really the first time where we've got some legislation in Canada that is going to provide individuals who are born using third-party reproduction with information about their genetic origins. So I think it's useful to take a look back to see where we've been and to see how we've come to this point. So in order to do that, I'd like to first talk about the now defunct provisions of the Assisted Human Reproduction Act, what was originally planned for Canada in terms of information disclosure for people born through third-party reproduction, and briefly describe a constitutional challenge that happened in Canada around the right to know one's genetic origins. I think this legislation in this case gives us a really good sense of what's at stake when we're thinking about the right to know one's genetic origins. And then I'm going to turn and look at to now enacted Bill 12 to see what the law provides and how this right to know one's genetic origins has been operationalized in this legislation. So we certainly know that when we're talking about third-party reproduction, we're referring to the creation or the birth of an individual who's born using either donated sperm, donated eggs, donated embryos, or surrogacy. And when a person is born through third-party reproduction, the intended parent or intended parents can choose to use an anonymous donor, so a donor who's not going to provide their identity, or an open identity donor, where some information is going to flow, including the identity of the donor to the offspring. And so these two types of information can be relevant to the donor-conceived person or to the person born through surrogacy in a variety of ways. When we think about non-identifying information, really what we're thinking about here is, personality traits, individual characteristics, hair color, eye color, hobbies, identification, their profession, that type of thing. But donor-conceived people and people born through surrogacy may also be interested in knowing more about the identity of the donor, who is the donor, and in some cases may want to contact the donor or surrogate, and so would want more than just this background information, really to be in touch with the person. And so it's important to keep these different types of information in mind when we're thinking about how to create donor registries and how to enact legislation that meets these differing information needs of people born through third-party reproduction. So we know certainly that third-party reproduction in Canada is growing. It's growing around the world. And with it, the demand for information has been growing as well. Okay, so how does the law seek to address some of the information needs of people born through third-party reproduction? So the legislators, when they're thinking about the right to know genetic origins or creating donor registries or surrogacy registries, are going to be concerned with a whole range of different types of information that needs to be regulated or needs to be collected and possibly disclosed. And as I've mentioned already, people conceived through third-party reproduction really benefit from a whole range of different types of information, whether it's health information, so a family medical history, psychosocial information, which I've also referred to. It can also include information about donor siblings, for example. So for individuals who are conceived using donated sperm, eggs, or embryo, they may want information about their siblings who are born using the same donor gametes. They may be concerned about inadvertent consanguinity, whereby they may inadvertently enter into an intimate relationship with a donor sibling because they don't know that they're genetically related. And so these types of concerns can be addressed in registries. Registries can also address a number of additional important concerns. So for example, limiting the number of families that are born per donor, or limiting the number of times that a person can act as a surrogate, in order to have regulations that can put those types of policies into place. It's really critical to have these types of information stored in registries. So for example, in Western Australia, there's a limit on the number of families that can be born through donor conception. And that is something that we could see in other jurisdictions as well. And of course, registries are also critically important for individuals who are undertaking research in terms of getting a snapshot or a sense of what's happening with third-party reproduction in the country. So a number of countries have taken steps to facilitate the flow of both identifying and non-identifying information to people born through third-party reproduction. They exist in a number of countries. They take a number of different forms. There's all sorts of variation between these different registries. They can be maintained by a government, or they can be maintained by a private entity or organization. They can be mandatory, they can be voluntary, they can be national, or they can be state-based. And they can vary in terms of the nature of the information that they collect and the information that they disclose, including whether the information is going to be non-identifying or identifying. And they may vary also in terms of who is eligible to receive this information. So when we're thinking about lawmaking in this space, there's a number of different considerations that may be at play. But really what is common among these different registries is that they establish a mechanism or create sort of an infrastructure that allows for the flow of certain information about the donors and the surrogates to the people who are born through their assistance. And so with Bill 12, Canada is now going to join the countries who have taken steps to collect and require the disclosure of certain information about donors and surrogates to those who are conceived through third-party reproduction. So where have we been? This is not the first attempt at lawmaking when it comes to the creation of a donor registry and providing information about one's genetic origins. The first attempt at this was through the Assisted Human Reproduction Act, the federal act. And that act initially created what we call a two-track approach to the collection, use and disclosure of information from donors. Essentially what it required is that it required both identifying and non-identifying information to be collected about the individuals who are donating their sperm, eggs, or embryos. And it provided for the disclosure of information to the donor-conceived person under certain circumstances. Okay. The reason we call it a two-track registry is because identifying information could only be disclosed where the donor consented to its disclosure. So all donor-conceived people would receive non-identifying information about the donor, but only in instances where the donor had consented to the disclosure of identifying information would that donor-conceived person have received any information that would identify the donor. Okay. That donor registry also created a system whereby an individual who was donor conceived could contact the registry and determine whether or not they were genetically related to a proposed intimate partner. And so that addressed those concerns about inadvertent consanguinity. Okay. Ultimately, however, these provisions were caught up in the constitutional challenge to the Assisted Human Reproduction Act, and in the reference, the Supreme Court of Canada and the reference regarding that act declared these provisions to be outside the lawmaking authority of the federal government. Court determined that these types of provisions about information collection, use, and disclosure fell to the provinces. Okay. There was hope initially that we would see some provincial legislation. Obviously, this left an important legal void for donor-conceived people. But the legislation was slow in coming. very slow. And in the absence of that legislative action, there was a constitutional challenge launched by Olivia Pratton, who's a donor-conceived person, in 2009 or so. So Olivia knew that she was conceived using donor sperm, but she had no information about her donor. And she brought a lawsuit in British Columbia arguing that the province's failure to provide her with information about her donor violated her constitutional rights. And among her arguments was that she had a constitutionally protected right to know her genetic origins that was protected by Section 7. Okay. Ms. Pratton was successful at trial, but she was ultimately unsuccessful on appeal. Unfortunately, the British Columbia Court of Appeal overturned the trial court's decision. But at the trial level, Ms. Pratton presented some really important evidence about the need for information disclosure, both identifying and non-identifying information to donor-conceived people. And the court, based on that evidence, recognized that a donor-conceived person has really compelling interests in having access to both that non-identifying and identifying information about their donor. Importantly, that trial judges' decisions on the facts, those factual findings on the evidence about the implications of not having that information, were not challenged at the Court of Appeal. And so they provide us with some really important insights and information about the importance of information for donor-conceived people. So the court found that with respect to health information, found that some donor-conceived people who do not have access to that information are at a real disadvantage from a medical perspective. And the court explained that donor-conceived people who have an incomplete family medical history means that they have a real lack of information that would help them identify the potential for a disease or to take steps to prevent a certain disease or to test for such a disease, okay? The need for that information is particularly acute, the court explained, because there's no knowledge of the donor's identity and because anonymous donation continues to be permitted in Canada. And so this was a fairly frequent occurrence. The court also found that some donor-conceived offspring who don't have access to psychosocial information can experience psychological distress, that has an impact on the formation of their identity, and that it's really critical that that information be made available to donor-conceived people. Okay, so important factual findings from the court. Unfortunately, as I've mentioned, the Court of Appeal, although I'm not setting aside those factual findings, did overturn the legal argument. And so again, we were left in this situation where there's this ongoing legal void for individuals who are born through third-party reproduction about how they access information about the third party who's contributed to their conception. So where did that leave donor-conceived people? Well, unfortunately, it really left people in a situation where they would use informal mechanisms like 23andMe, they'd use DNA tests in order to try and learn more about their genetic origins, which in my view is a wholly unsatisfactory way for people to be trying to uncover critically important information about their identities. Okay, and we've seen hundreds, if not thousands, of these kinds of headlines over the years. Okay. Some individuals would use private donor registries. So this is one example of a private donor registry, the donor sibling registry. which operates out of the United States. And it's played a really critical role in enabling some donor-conceived people to build relationships and find their half-siblings. But again, this is very much an incomplete answer to ensuring that individuals have sufficient information about their genetic origins. All right, so that's all of the background. That's the path to how we got where we were before Bill 12 arose. And so I'd like to now spend a few minutes providing an overview of what this new Quebec law provides. As I've discussed, we've seen sort of some of the options about how governments can create registries and what kinds of information collection and disclosure provisions can be established. So I'm not going to provide you with sort of an exhaustive and detailed description of what's in the new law. It's quite complex. And as Stefanie has mentioned, there's still questions remain about what the regulations are going to look like and how some of this is going to work. But I do want to give you a sense of what this new law does. So most importantly, the new law recognizes the right to know one's origins in favor of any person who is born through third-party reproduction. And that includes sperm, egg, embryo donation, and surrogacy. Okay, so who has a right to access this information? Bill 12 provides that a person born of third-party reproduction, including a person who is under the age of 14 and has the permission of their parents, has the right to obtain information from their government about their donor or surrogate. Okay. Importantly, individuals who are 14 years of age or over, and they are first-degree descendants of a person who is born through assisted reproduction or third-party reproduction who's been deceased, they also have an entitlement to access certain information. As I say, when the individual who's born of third-party reproduction is deceased. So this ensures that things like that family medical history will be available. So what type of information is available to be accessed? Under what circumstances will that occur? So the law provides that it's the parent's responsibility to inform the child of the fact that they are born of third-party reproduction and the type of information that is available to them in the registry. And there is a wide range of information, or at least appears that there's going to be a wide range of information that is available to that individual. The first is the name of the third party. Okay. There will also be information from the third person's profile. What is going to be in that profile is going to be left up to regulation. In some of the transitional provisions in the bill, there's some indication of what that looks like. And not surprisingly, it's things like age, height, hair color, hobbies, education, that type of information, but more details to come on that when the regulations are promulgated. There will be contact information available for the person unless there is a contact veto in place. So the law establishes a requirement that the person conceived through third-party reproduction is only permitted to access that contact information where the third party, the donor or the surrogate, has agreed to, has not entered into a contact veto. Okay. There are also a number of documents that are going to be made available to the individual. They will have access to the judgment concerning their filiation, a copy of the surrogacy agreement, any other documents in the judicial file, and then again, there's sort of this catch-all documents that may be listed in the regulations. So a fairly wide range of information is going to be available to donor-conceived people and people born through surrogacy, much broader than what we saw under the Assisted Reproduction Act. This is a much more generous and fulsome amount of information that will be made available. The law also provides for the communication of medical information to a person who is born using third-party reproduction. So if there is an example, if for example, there's some need for some information, medical information to be communicated to that individual, there are provisions in the Act for that type of disclosure to happen. The law also provides for psychosocial support services to be made available to any person who is taking steps to access information from this registry. And I think that's critically important given the significance of some of the information that's going to be available to the individuals who will be accessing the registry. So do we think that the bill goes far enough? Do we think this new law goes far enough? In my view, there really is much to be commended in Bill 12. It really is, the enactment of these provisions is really critical. Quebec will become the first province in Canada to take steps to ensure that certain information is available to individuals who are conceived through third-party reproduction. This is a really major advancement in Canada. I can't really stress that enough. Second, I think this new law really satisfies many of the needs that were identified in that Pratt litigation, much more so than the previous federal provisions. It ensures that information is preserved and maintained in a registry. And although, as I say, it's too early to say sort of the precise nature of all of the information that will be collected and disclosed, it's clear that there's going to be a very full, wide range of information for individuals who are seeking to know more about their genetic origins. And then the third thing that I think is important about the law is it really seeks to strike a balance between the interests of individuals born through third-party conception and those who have participated in that process, either by donating their gametes or by acting as a surrogate, by enabling that contact veto to be in place. And that a similar mechanism really exists in adoption law as well. So I think that the contact veto does strike an important balance between those interests. Despite those important benefits, however, I do think that the law falls short in a couple of respects. First and foremost, the law, as I mentioned, places the responsibility of disclosing the manner of conception, that is how, the fact that the person was conceived through third-party reproduction, on the parents. Although there's a mechanism for an individual to reach out if they suspect that they're conceived through third-party reproduction, to reach out and access that information from the minister. That onus really rests on the person themselves or on the parents. And this is unlike in some other jurisdictions where there's an annotation, for example, on the long-form birth certificate, so that an individual knows that they've been conceived using third-party reproduction, that there's more information available for them with the ministry. So this law could have gone further in ensuring that individuals who are born in this way are aware of the manner of their conception. There have been cases, of course, where intended parents have not told their children that they're born through third-party conception, and the secrecy that surrounds the manner of conception can result in really significant harms that we've seen reported in some of the empirical research in this area. My second concern, and I will close on this point, is really that the most significant limit of this registry has nothing to do with the Quebec legislature. It's just that it's province specific. So the province has done a great job in bringing in this bill, but I think that there are important limitations when we think of a donor registry, a surrogacy registry that exists in one province in Canada. The disadvantages of a province by province approach, of course, is the risk of having a real patchwork of systems across the country. So that means that, there's going to be donor registries in some provinces and not others. Some provinces providing more robust information than others. I think this having a provincial-based registry also sort of limits the ability of lawmakers to engage in lawmaking around, for example, limiting the number of children who are conceived through donor sperm. So I do think that there are some important limitations in the fact that it's simply a registry that's going to exist in one province. This is my pitch. This is always my pitch when I can speak about donor conception, donor registries, and surrogate registries is, the need for us to take action at a federal level in Canada. As I said, I think this is really commendable what is happening in Quebec. But I do think that there are opportunities for provinces to engage in cooperative federalism here and come together to create a federal registry. We've got a good model in what Quebec has established. And if we could see these kinds of approaches adopted in other provinces, come together and have that regulated at a national level, I think that would be much more effective. We have examples of this already in Canada through CIHI, Canadian Blood Service, and others, and I'm happy to chat more about that in the questions. But just to conclude, again, I'm really thrilled to see that Quebec has created this donor registry. Third-party reproduction, as I've mentioned, is an increasingly common method of family building. And steps really need to be taken to ensure, not just in Quebec, but across the country, to ensure that individuals have much needed information about their donors, their donor siblings and their surrogates. Thanks very much.
Okay. Thank you, Stefanie and Vanessa. What's really interesting. And I'm looking forward for the question and the answer you will provide. Where is the chat?
Here, I think it's here.
Yeah.
No, it's here. Can I take
Yeah.
this?
All right.
There it is.
So please feel free to ask your question, even orally or by writing them in the chat. So it would be a pleasure to see you, those who are at distance. So don't hesitate to open your camera if you want, or to just ask for raise your hand and ask for to be able to speak. So in the meantime, I will take the question from the floor here at the University of Ottawa. So yes.
I actually have a question for each of you. Should I ask them both together or whatever?
Yeah, why don't you ask them?
Okay. I was curious about the surrogacy. I know you've mentioned that they're maybe like cutting down on reimbursements and there's issues around consent. And I don't, this isn't something that you directly raised, but it made me wonder, are there rules around adverse health impacts to the surrogate in these laws? Like what happens? Because presumably fairly frequently in labor, things happen, right? So does the reimbursement continue after, or are there kind of issues around that?
So so we don't know what Quebec is going to do about that in particular. We do know in practice, there are often provisions that are put into agreements that say that, yes, in the event there's some sort of complication or she needs to be on bed rest following the birth, that there is some provision for, let's say, lost wages, which are allowed, and also for reimbursement of certain things. What's really interesting also is that has developed into a norm and a practice, and it's something that Health Canada even says on its website is allowed. It's technically actually not allowed under the law, which actually says you can only be reimbursed for expenses or for lost wages during the pregnancy, not afterwards. But again, in practice, it's actually developed that people do this, and it has kind of been accepted by the government as something that does not break the law. But yeah, Quebec hasn't told us what they're doing about that yet. Yeah.
And then did I understand you correctly when you said that one of the things that will be available through the registry is the name of the donor? That
Yes.
seems.
Yeah, so identifying information will be available. So it's important to distinguish between knowing who the person is and being able to contact that person. That's the distinction that the legislation draws. So you'll be able to have the identity, but whether or not you have the contact information, I know in the age of the internet, that's the question, right? Whether or not you have the contact information is guarded by that contact veto provision. So.
And is that also going to apply to adoptions?
So these kinds of registries already exist for adoption. These kinds of provisions already have existed actually for quite a long time for adoptees. And that was, I didn't get deep in the weeds in the Pratton case, but one of the constitutional arguments that she raised was that the adoption legislation was under-inclusive, that it violated Section 15 because individuals who were born through donor sperm and donor egg didn't have access to the same kinds of legal provisions as those born as a result of who had been adopted and therefore had certain information about their birth parents.
And is there a concern about like a chilling effect on sperm or egg donation because of the identifying?
There has been, I think when we talk about information disclosure, there is always a concern that the result may be that people don't want to donate their gametes anymore, that they prefer to be anonymous. To my knowledge, this hasn't necessarily played out in other jurisdictions where anonymous donation is restricted or prohibited. What does happen is sometimes the donor profiles change. That it's individuals who have finished building their families, for example, and who are interested in or, committed to helping others build their families who may decide to donate their gametes. But that is always a concern that arises. So as I say, we'll see what happens. We're very, very in the very, very early days, but yeah.
There's another question on the floor.
Yes, it's one for each of you as well. Thanks for the great presentations. My question for staff is, I understand there is some debate about the language that should be used to describe the person who is pregnant and whether it should be femme, personne porteuse. I'm wondering if you can talk a little bit about what happened and if you have any advice about what it ought to be. And then my question for Michelle, with the apology that I did not read Bill 12, so I understand the mechanic. It's about, could a contact veto be revoked by a person? And then at the same time, I'm thinking registry, I sign up, well, the child is now 16 or 18 looking for information. My contact information is going to be out of date, maybe. Is there an obligation for the general direction of electors or the motor vehicle registry to do information sharing? Is there any sort of provision to ensure that the registry information remains up to date on that point?
So the question was around, just for people online, the question was about what language was used in relation to the statute. This is a really important thing that was discussed in relation to Bill 2, which is the predecessor to Bill 12, because in part, one of the things the law was intended to do was also to be more inclusive and to recognize that not everyone, let's say, who acts as a surrogate, self-identifies as a woman, and so to use more gender inclusive language. So this is really important. Lawmakers address this in the end by using the language of a woman or a person. There was some discussion about whether it should just be person as opposed to a woman or a person, and lots of debate around, should we use language of woman as well to recognize that most people, at least currently, who act as surrogates identify as women. Again, hotly debated about whether we should use that, and also in relation to surrogacy, what language should be used. Should it be surrogate mother? Should it be femme porteuse? Should we use gestation pour autrui in French? There's really lots of different connotations associated with the language. My view is, I think this is a really important step to be more gender inclusive. I think that maybe we could have used personne to reflect kind of everyone instead of femme ou une personne, or woman or a person. One of the things that also is a bit tricky about this bill is that the way in which it's drafted in seeking to be inclusive can sometimes be a bit difficult to get through. I think they could have used some short forms in the drafting of the bill. Again, this is kind of really getting into the weeds, and I know it's very much in your area, but like they could have used the language of surrogate and then defined it and then used surrogate throughout instead of continuously saying a woman or a person who agrees to carry a child for another person, because it actually makes the bill just quite difficult to read. But again, I think overall, I'm pleased with what they did there. Maybe in the French language, I had some different suggestions for some of the language that they could have used to ensure that it would be gender inclusive. I think that there's some things that were done that do lean a little bit more towards not being as inclusive as I'd like them to be. We'll put it that way. I'll leave it at that.
But did you want to add something?
Nope.
I think the question was also more related to, are we sure that there's going to be a follow-up, an update of the information that will be on the file?
For the registry.
For the registry. Yeah. Yeah.
Okay, I can try and answer that. I think it's too early really to say. Michelle might also have some thoughts on this. She's extremely familiar with with this piece of legislation, but I do think we're going to know more when we see what the regulations look like. The statute does provide for some requirements for information to be collected from a whole range of different sources, from clinics, from parents, from all sorts of places. So presumably, if we have contact information, that contact information one would hope would be up to date, and there would be some requirement to ensure that a relevant information is up to date and in the file. There's certainly, I think, one really critical piece. This is a bit of a tangent to the question that you've asked, is the provision that allows for when relevant new medical information comes to light, that there is an explicit provision in the Act that enables that information to get to the people who need it. So, people often donate and act as surrogates when they're young, and their medical conditions may change over time, and there may be medical information that comes to light that's really crucially important. And I think the fact that there's a provision that enables the flow of that information is really beneficial. So, but we'll see how the contact info will work. Do you have anything to add, Michelle?
No, it's a perfect answer, I think. We have a question on the chat. From Vicky Meyuyas, is there concern about encouraging medical tourism within Canada with these new restrictive rules in Quebec? And who wants to answer?
That's a good question. I think it's a good question, but I'm not sure. Maybe I'm not thinking about it in the right way. Like, I'm not sure what it would encourage.
People are going to go out of Quebec. I think that's the question. That people are going to go out.
Or is it going to increase the traffic or the tourism outside Quebec?
Oh, okay. So that
have an impact outside of the
like driving to Hawkesbury and stuff, because that might change the whole format.
Yeah. So I think certainly people will be encouraged to circumvent the law to drive outside of Quebec. I wonder if the part of the question, though, and this is why I wasn't sure. And again, I don't want to pressure Vicky to come online, but if you want to further clarify, I'd be happy to see you and engage with you. But whether it also means that people are now going to be, from, let's say, outside of Canada, going more to other provinces to avoid Quebec. I think that, to be honest, has already been happening for some time. People have been really afraid to go to Quebec in part because a lot of people have warned them against going there because of the rules around special consent adoption. And so in some ways, we're just going to kind of see a continuation of that, where lawyers and other professionals working in the area have really told intended parents quite a lot. You should be avoiding Quebec at all costs. You should not work with a Quebec surrogate. And if you do work with a surrogate in Quebec, she should travel outside of the province in order to give birth, so that the rules in Quebec don't apply to her. And so I think in these instances, like, again, I'm not sure if it's going to change very much. And if you have further questions on this, I'm quite happy to answer more if I haven't fully understood the question.
So Vicky, without imposing that on you, okay, she's fine. Okay, any other question on the floor or at distance? We still have a few minutes. Maybe while you think about it, we can try to discuss one issue about the birth certificate, whether it should contain more information, because for me, that's a that's a true dilemma, you know, because it has pros and cons. And I think personally, I'm not so sure about the fact that it's such a good idea to put it on the birth certificate, the circumstances of the birth. But I would be, you know, curious to see more about your position. And I do believe that it will be very, very important to have some education, because even if you have an obligation from the parents, I agree. I mean, the psychosocial research demonstrate that parents want to tell, but they don't, all of it. And, you know, they don't at the beginning, and then they don't find the right moment. And there's a lot of issues around that. So, yeah.
And then somebody inadvertently tells them at
Yeah.
over a family holiday dinner that their donor conceived. Yes, exactly. So I think with the birth certificate, I agree. It is not sort of a very clear cut. There's no clear cut answer. And I think some of the concerns arise certainly with annotating the short form version of the birth certificate is then you're essentially telling everybody who needs to see your birth certificate that you're conceived in this way through third-party reproduction. I think, however, if you annotate the long version, you know, that's the version that you don't really carry around with you or, you know, use to register for school or that type of thing. So I do think that there's an important distinction between the short form and the long form birth cert. And as I say, the concern really there is about the harms that flow from secrecy, which I think in many ways are actually can be much more harmful to an individual than some of these questions about knowing who the donor is or knowing who the surrogate is. I think that secrecy about how you're conceived can be really, really, for some people has been reported to be very, very harmful.
Thank you. And since we don't have no more question, I would have another question, and please do write a question on the chat or open up your camera and ask a question orally if you're at distance. But Stefanie, I was wondering, why do you think, I don't know if you could say a few words extra, you addressed it in your conference, but why do you think, and I tend of have a tendency to agree with you on that, why, you know, we should have left and Bill 12 some discretion for the court to intervene in the case where the surrogate doesn't consent to relinquish the child.
Yeah. And so this is something, so there's a couple of reasons for this. One is that, I mean, I think a number of provinces have done this, and I think this is in order to recognize that there may be situations, as I mentioned, where a surrogate does not wish to be the parent, but is not providing consent for other reasons. So we actually had a case in Quebec that had arisen where they had worked with a surrogate outside of the province who lived in Tennessee. And the surrogate had disputed the expenses that had been paid to her, or actually it might have been actually claiming payment because she lived outside of Quebec and outside of Canada, and said, you know, you still owe me $7,000, so I'm not going to be providing consent for you to be recognized as the child's parents. And in that instance, based on the rules we had in Quebec, the court was not allowed or not able to provide for the adoption because she did not provide consent. I think that's a very clear instance where we should not be allowing someone to say, I don't consent, and therefore you cannot be recognized as the parents. And so I think allowing for judicial discretion in this area would allow, especially in those very clear cases where I think it would be in the best interest of the child to recognize the intended parents, a court to intervene. And then even for the other reasons that I mentioned as well, and I just kind of alluded to this in the talk, in terms of being able to recognize the intended parent's contribution as well. One of the other problems, and I didn't mention this in relation to Bill 12, because now without judicial discretion, it actually doesn't make a huge difference in relation to surrogacy, is that there could have been the possibility of allowing for judicial discretion and also allowing for the recognition of multiple parent families. So if you did have a situation where, for whatever reason, the court determines that the surrogate should be recognized in addition to the intended parents, that all of them could be. And of course, this is hotly debated. It's really difficult. I don't actually know fully how I would come down. It would depend upon the particular circumstances of the case. And that's why, again, judicial discretion is problematic too, because then there's a question about how is a court going to make a decision about what's in the best interest of the child? Is it going to be, let's say, to have all the parents be recognized? Is it going to be to just have the intended parents be recognized? Would it be like, what would they decide? But I think how I've come down on this is that allowing for that discretion is better than not allowing for any discretion. And in that instance, having the one intended parent and the surrogate be recognized together and not allowing for the other intended parent to be recognized. I think that that's deeply problematic.
Thank you, Stefanie. Do you want to add something? Maybe since there's a thank you note on the chat. Thank you, Dara. But maybe a last question, just to, on the floor.
Yeah,
yes,
this might be a bit of an odd question, but I'm thinking, okay, you're allowing in some, they're no longer absolutely no, right? Contracts, right? Well, courts are not quick. Pregnancy is 9 months, right? Should we not be concerned in some ways that, some of these remedies might not be realized in the time when it actually matters, right? Like expenses you have during pregnancy, you had during the pregnancy, getting payment a year or two later, it goes to the Court of Appeal, you're spending legal fees. Like, might we actually be creating additional problems to actually enforce some of what the new law technically provides?
Stefanie?
So actually the answer to the particular question that you asked about like what happens, let's say if the surrogate were to have expenses that aren't paid during pregnancy and would need them kind of paid right away. Actually, one thing I didn't mention that the bill does is it actually mandates that a notary would hold in trust money for the surrogate's expenses to avoid that kind of situation. And so that's actually it's really interesting because when I was doing some empirical work with lawyers, some of them had said to me, we should allow the surrogate that right to potentially not provide consent because that provides some protection for her in the event the intended parents do renege on their promises and don't provide, let's say, the reimbursements that are provided. And my argument has been in response to that, well, that's not the best way to address that. Really, the way to address that is to ensure that she's reimbursed, but don't necessarily provide this kind of ability for her to say, no, you're not going to be recognized as parents until I'm reimbursed. And so by having this, the notaries hold the money in trust, that kind of could protect the surrogate in that situation. I think that's actually a really good thing. The other thing this does that I think is helpful as well is by having the notary hold the money in trust, that's going to take away basically the role of that many agencies are currently playing in holding money in trust. And that's a whole other kind of topic here that we didn't get into, but agencies are technically prohibited from accepting payment in order to match surrogates' intended parents. Many of them are doing that. There's different ways in which they frame what they're doing. And then one of the other things that they often do is hold money in trust to reimburse surrogates' expenses. And there's been some empirical evidence suggesting that in those instances, payment is actually happening. And they're kind of engaging in practices that go beyond what's allowed in the federal law. And so I think there's actually a lot of good things about Quebec's provision around a notary holding money in trust to disperse to surrogates.
Yes. Thank you for the question. I was wondering, just to finish this seminar, what would be the lesson, the lessons that we can learn from, rest of Canada in Quebec, dealing with the consultation with a lawyer, what have you learned from the fact that you already have that rule implemented in British Columbia, in Ontario. So that would be one question. And in terms, maybe we can leave that there for now.
Okay, so the question is, what can other provinces learn from Quebec, or is it the other way around? Okay, what can Quebec learn from other provinces? Okay, so I think one of the things
pluriparentality as well, that was the other thing that I was thinking of.
Yeah, well, I think one of the things that's difficult is, yes, there's a lot of things that I had argued that Quebec should borrow from other jurisdictions, but now, the law has passed and we're kind of beyond that at this point.
Maybe not for the future, though.
Yeah, so maybe for the future, I mean, one of the things I would have liked to see, and I mentioned this already, is the recognition of multiple parent families. I think that this was a really big missed opportunity in Quebec. And without real justification, I think lawmakers have said, well, we have no evidence that this is in the best interest of the child. I don't know where that idea came from and why they were so resistant in a lot of ways. And so I think I would have really liked for lawmakers to look more carefully at Ontario and BC in terms of that. Also in terms of, as I mentioned, the judicial discretion. They did look to, Ontario and BC in terms of allowing for this more faster process for the intended parents to be recognized without going to court. And so I think that was something that was borrowed, but I think that some of the restrictions that they've placed on that, they could have, I think, been a little bit, made this a little bit less difficult for some intended parents, and in that way have followed Ontario and BC.
Yeah, thank you. And in terms of the meeting with the psychosocial professional or with a lawyer, do you want just to add? And I think that would be the last comment that I asked you.
Well, in terms of the counseling, that's not something that's actually mandated by other provinces. It's a norm that is developed where parties do typically at the insistence of their clinic go to obtain counseling. I've heard mixed things in the empirical research that I'm doing about the utility of those counseling sessions. They say some counselors are absolutely wonderful and amazing, and it's super helpful. In other instances, not as much. And so, in terms of Quebec actually regulating that, I have some questions about what they're going to mandate those sessions look like, and how, and I don't know how much they can actually learn from other provinces. They can maybe learn from some of the empirical research that we've been doing, but we don't kind of have that research out there yet to inform that information. We will soon. And in terms of the contract and independent legal advice, that was something that was required in Ontario as part of their parentage process, that the parties have to obtain independent legal advice. Again, I would have liked to see that in Quebec. That was something that also had developed as a norm prior to actually being codified in the law. And that I think, I have heard is really potentially quite useful for both intended parents and surrogates to have their independent legal representation and to be advised on their own about what their legal rights and obligations are pursuant to these arrangements.
Do you want to add something?
No, I would just reiterate that, we're in early stages of empirical research that's demonstrating the benefits of some of those provisions.
Great. OK. Alors, merci beaucoup tout le monde en présentiel et à distance. Thank you, everyone from distance. And is there another question?
No, I think Dara's just clapping.
OK.
It's a comment.
Oh, it's a
comment.
Mm-hmm.
OK. OK. So there's a few comments. This was wonderful. Thank you. And this one from Dara, it would be great if laws would allow IPs to cover anticipated costs and then to receive receipts afterwards. So donors and surrogates do not have to lay out funds out of pocket, etc. We addressed that. Thank you so much for this comment. And thank you for your attention. Thank you, Ali, for your comment as well for this excellent session. So thank you, Stefanie and Vanessa. It was really helpful, and we look forward for your research publication in the near future, and have a nice rest of the day. Bonne fin de journée à tout le monde. Merci, au revoir.
Thanks, everyone. Thank you.